Thank you. All right, welcome to the House Committee on Government Operations and Military Affairs. It is Friday, February 24th. We have a full house here and have survived some very rough roads, some of us. So appreciate everybody's patience this morning. We're here to pick back up and look at our H97 and act relating to a bunch of elections policy. Here with Ledge Counsel, Tim Devlin. Tim, can you remind me what the number is for the latest version of the bill and
yes,
take us through the latest draft here?
Sure. The latest draft is 3.2, and it should be dated to this morning at 9 o'clock. For the record, my name is Tim Devlin, Legislative Counsel. The bill you have before you, well, it's actually, sorry, strike all amendment to H97, has two significant updates since the committee last reviewed version 2. And those are, let's see, this iteration has removed the prior section 3 regarding independent candidate filing deadlines. That was to amend Title 17 VSA 24.2 that no longer exists. And this also includes clarifying revisions to the language regarding voluntary candidate demographic information in 7 and 8. The highlights you see throughout here include the new language that I just referred to, as well as yesterday's newer language that the committee was most recently looking at. So those sections are highlighted regarding campaign finance limits for statewide candidates, as well as the write-in candidate minimum thresholds has not changed, actually. And let's see, so looking at the new text regarding demographic information that will be voluntarily proffered by candidates, I would point you to page 5 at the bottom, section 7. And this amends Title 17 VSA, section 2361B. Starting on line 17, it will read, the consent shall set forth the candidate's name as the candidate wishes to have it printed on the ballot, the candidate's gender, age, or race or ethnicity, town of residence, correct mailing address, and email address. The candidate who does not provide information pertaining to gender, age, race, or ethnicity may still appear on the ballot if all other requirements are met.
Yeah, let's pause there. I think that this fixes the issue that Eagle Eye former Representative Barbara Murphy brought up in her testimony yesterday. I just want to take a second with the words on the page and make sure we feel like this is crystal clear that the demographic information is not required, but the name, town, et cetera, still required. It looks sharp to me. Getting the thumbs up from Director Senning too. Anybody on the committee have any? I think we got it. Okay.
Section 8, which amends Title 17 VSA, section 2665, which is titled Notification of Secretary of State, is altered and will read as follows, starting on line 6. The town clerk shall file with the Secretary of State a list containing the name, gender, age, race or ethnicity, street address, and email address to the extent the information is provided by the candidate, and the end date of the term of office of each select board member, city councilor, village trustee, and mayor elected. The town clerk shall not be required to ask the candidate for information pertaining to age, gender, or race or ethnicity if this information is not provided to the town clerk.
I'm going to pause here. So the town clerk is only required to file the information that's provided by the candidate.
Yes.
Do you have a question, Representative Hooper?
No, I just put on the record, I still had a problem with the entire packet of information going forward as opposed to aggregating non-descriptive for the representation of power. It might even promote more people to fill it out if they knew it was not going to be attributed to a name.
Yeah, I think we've kind of circled on that. Representative Hango.
So, building on that, it just occurred to me that there could somehow be a way to separate the name, the identifying information from the demographic, information relating to gender, age, race, or ethnicity of a candidate. So there would be two separate buckets of information, one of them which is available to the public and the other which is just collected on the website as anonymously. We have one candidate who identifies as a particular race or ethnicity who is 60 years old or 20 years old or whatever. And that would, I would think, appease Representative Hooper if that could be done.
Could I ask Director Senning if you're willing to, could you comment on that? Yeah, would you mind?
Sure.
I'm not opposed to that, Representative Hango and Representative Hooper. I just was under the impression from our previous testimony that it was either we collect the information, make it public as it's presented, or we don't collect the information, that we kind of had to do either or. But Director Senning, could you help clarify that and jog our memory?
Sure. Will Senning, Director of Elections, for the record. We did talk about it briefly. I believe the way I put it to you is, for once this information is filed with me as a Public Records Act matter, I need to make it available when requested. And I don't think any of this information is among the current exemptions in the public records law. No. That leaves a middle ground though, right, which I'll acknowledge right now, which would be I could collect the individual forms. We could produce a candidate list in terms of the primary candidates where this is also collected, and a select board member list, which we already produce, that just has the name and address information like we do now, and not proactively post the rest of this information. Then, because this is coming to me right now, I would want to think about and potentially ask my staff, but it would be us who would be in the position of having to do the aggregation. And we could potentially, I don't think it would be too much of a burden on my office. My staff is back there pounding on their desks right now. To do that aggregation and publish the aggregate numbers. If that was what the committee would like to do, to write into the bill, that's a little additional work on our end. It still would not protect these folks from a request for the forms themselves.
And I think, there probably could be a really easy IT fix to that, where a computer program could just say these particular columns would go in one bucket and the other columns go in another.
You're right.
bucket.
It's not a heavy lift.
It's to my mind, just a step away from allowing crazy people to do crazy things. And an excellent opportunity, Mr. Devlin, I think, for a notwithstanding the public disclosure.
Okay.
I wouldn't even mention.
So I want to bring us down into the bill that we're working on. I am very cautious of getting into the Public Records Act here. So here's what I'm going to put on the table and see what the committee thinks. If we said the Secretary of State shall make the currently available candidate information, will publish that, but will only make the demographic data available on request or in a de-identified or aggregated form. If we said something to that effect that accomplishes that, would that be preferable for the committee? Representative Chase?
Have a separate optional form for demographic information with no identifiable information. So it just kind of
Just
goes into a summary.
Yeah. So I didn't want to reopen this whole thing today. What I'm worried about is what we want to do is to try to make it easy for people to report, right? And we want to make it easy to collect the data. So I appreciate the creativity. I think where I'm willing to make one more edit here in this piece to try to appease some of the concerns is to just say, that as a matter of policy, we expect that the currently available information will be published, but that the demographic information will only be published actively in an aggregated form, knowing that obviously with the Public Records Act, if somebody actively comes with a public records request, the demographic data, the consent forms themselves would be made available, but not some spreadsheet that makes it easy for people to control particular types of candidates. Yes, Representative Hango.
So if somebody comes to your office, Director Senning, and has a Public Records Information Act, what am I trying to say? A request for information. They could then say, I would like to learn more about Joe Smith, but they have to have a reason for learning more about Joe Smith. Now they could access anything. Okay, so then you would provide them with their consent form, the consent form that was filed that has the identifying information and the demographic information.
If they specifically ask.
If they specifically ask for it, but that's the only way the public would get it.
Yeah.
According to the scenario we just discussed.
Yes.
Prior to Rep. Chase suggesting a separate form. Okay, I'm okay with that.
At a separate form, they could ask for those forms.
Representative Hooper.
I'm okay with your proposal also, although I think we have to keep in the back of our heads that when it's elective to submit it or not, it's pretty questionable data in
Right.
terms of what our legislature looks like if only half of people fill out the.
I think it'd be easy to figure out the percentage of people that actually completed it though, by just looking at aggregated data. So that would tell us whether it was useful or not. We're trying to make it useful and also satisfy some of the, candidate harassment and safety, frankly, concerns that I'm hearing. So Tim, do you think that you could add a piece to each of these sections to accomplish that distinction between only actively publishing the aggregated demographic data while, to make it clear that we're directing the Secretary of State in that way?
I would point out, neither of these sections currently, and the law otherwise, doesn't require me to publish it right now. The candidate listing is obviously something we publish and is, highly sought after. I would never stop doing that as a public interest kind of thing. But I just don't know if we could leave it unsaid. And I guess at this point you want to say it because we have this important sensitive data involved. So we should make clear what's published and what's not.
Yeah. How long would you need to put that together, Tim?
We could probably do that within 15 minutes or so.
Okay, great. Let's take a 15-minute break.
One other point, just in case it helps, and I don't mean to, if it takes any of the edge off of this, you all should remember, right, what you publish on the legislature's website. Mm-hmm. It has your name, a picture of you, most times where you live. So most of this demographic information can be gleaned by what is already posted in your personal profiles on the legislative website.
That is a very good point, but this particular concern has come up so many times outside of this room already that I think it's worth it for us to take a few minutes. So let's just, before we take a break, let's take a quick jog through the bill section by section and just make sure that this is the last edit we need to make. Need to ask Tim to make. So Tim, you want to head up back up to section 1 and we'll just kind of just go through section 1. It's this, and we'll just take a real quick breeze through.
Sure.
Sure we got it.
The first part regards sewer loser laws. And this entails 2 sections. Section 1 deals with nominations by party committee, and section 2 deals with independent candidates. I think it's easy just to read the new text here. It amends Title 17 VSA 2381, subsection C. In no event shall a candidate who loses a majority party primary be nominated to appear on the general election ballot pursuant to this subchapter by a committee of any party other than the party for which the candidate appeared on the primary ballot. Jumping to the top of the next page, we have similar language, but for independent candidates, which reads, a candidate who loses a major party primary for office shall not appear on the general election as an independent candidate for the same office for which the candidate lost the primary election. The next part, I should note here, this is the part in the bill where there was language about independent candidate filing deadlines, which was removed in this version.
So the old section 3 is gone, everything else moved up a section?
Yes. The next part entails campaign finance limits for statewide candidates. You can see in the highlighted text on line 3, this simply adds the requirement that a political party shall not accept contributions totaling more than $100,000 from a candidate. Pause there. The next part regarding biennial committee reorganization reporting, it's just the one section, section 4. And this inserts the requirement that, on line 20, at the same time of filing the certificate of organization, the chair and secretary shall file with the Secretary of State a single machine-readable electronic document containing a list of the names and addresses of the town and county committee members from those towns and counties that have organized pursuant to this chapter. The next part of the bill pertains to nominee parties printed on ballots. This is just one section, section 5. This removes much of the text in subdivision A, in particular all of subdivision 1, and updates the subsection to read as follows. If a nominee is nominated by more than one party, the Secretary of State shall print on the ballot those parties next to the nominee's name by listing in this order. 1, the major political party for which the nominee had the nominee's name printed on the ballot in the primary. 2, any major political parties for which the nominee won the nomination by write-in vote. 3 and 4 have not been altered, but I can read through those if you'd like. Okay, and let's see. Then we skip down to subsection B on line 11, and we where there's kind of cleaning up of some gender terminology and just striking other language there. The next part of the bill regards candidate
Representative Cooper has a question. Sorry.
I apologize. My brain is working slowly. A party shall not accept contributions, plural, totaling more than $100,000 from a candidate. Is that in any way clarified by an individual candidate? Our intention is not for somebody to construe that to be candidates in general have a cap of $100,000 towards the party's coffers.
Right.
That's not how I would advise if I was giving guidance on that.
Thank you.
The next part of the bill on page 5 pertains to candidate demographic information. And this is something I had spoken to earlier. Would you like me to revisit this, Chair McCarthy, or just skip down?
No, I think since that's the part we're going to be focused on when you get back, I think I'll take that up then.
The next part of the bill is towards the bottom of page 7 regarding electronic ballot returns. This is 2 sections. Section 10 regards the signing certificate. Section 11 dives into the details about the portal in which voters with illness or disability and voters in military service or being abroad at the time can submit into return ballot electronically via portal established and maintained by the Secretary of State.
Except for the section numbers, that language has been the same for the last couple.
Correct.
Couple of drafts. Okay.
Yes, that has not changed. And that leads us to the effective date, which has not changed either. And that's the conclusion of the strike amendment.
Anything else before we let Tim go off and clarify our aggregate piece here? All right, great. Representative Chase.
Page 7, line 4, the candidate may qualify as primary winner. Should that be may or shall?
Sorry, where are you?
Page 7, line 4.
Writing candidates.
You know what? It should be may, but I actually was going to just bring up that particular 3 lines.
Okay.
I noticed in my last review of it last night that I think it would be a lot cleaner actually if we just omitted lines 3, 4, and 5, that entire subsection. It's unnecessary. I'm not sure where it came, how it came in. It's unnecessary because the subchapter that refers to the party nomination process is very clear that when you fail to nominate somebody via a primary, that is one of the reasons which you then can make a nomination by party committee. That in accordance with subchapter 2 of this chapter, the last clause sort of points back to exactly what I'm talking about. But this is really surplusage. I'm sorry I didn't flag it before.
So this language on 3, 4, that was struck in previous drafts. This is the language yesterday where we said, right? Am I on the right?
No.
That's at the top of page 7.
That we revived.
That's what I thought.
Yes, we
think it
revived this, but you're talking about this. right?
This was not what was revived. That was the
Right.
accepted if the write-in candidate receives more votes than a named candidate on the ballot.
Okay.
We
That was-
wanted that
right.
and it was mistakenly
Okay.
struck. This I believe is just brand new during this drafting of this piece of
Sorry,
legislation.
Director, say this is slightly outdated, so it's,
Yes,
the
same.
lines are a little different. So Representative Chase is referring to.
The lines
these
are different. I thought
and
this was on the right draft. I'm on 3.1.
Yeah, sorry.
Yeah. So
Sorry.
let's get on the same page.
Oh,
Yeah. So,
3.1 to the 3.2.
okay, so let's get on the same page here. So Tim, can you tell us exactly what we should be looking at?
Representative Chase is referring to at the top of page 7 of draft 3.2, lines 3 and 4, which is the highlighted. Director Setting is referring to the subsequent subdivision B.
Okay, so lines 5, 6, and 7. is
5,
that
6, and
correct?
7.
Of this.
Yes.
Oh,
Okay, now we're on. Yeah.
I apologize, you all.
Okay.
All right, so let's really zoom in on that. If no candidate is determined to be the candidate of a party pursuant to subsection A of the section, a candidate may be nominated. Okay, so what you're saying is that's already.
It already says in the party committee subchapter, you guys can nominate people in the event that there isn't one nominated by primary.
That is crystal clear now.
All right, so we will, in draft 3.3, we'll strike lines 5, 6, and 7. Okay, redundant. Okay, thanks.
Can I circle back to my question then, of
Yes.
may versus shall for line 4?
Because you were talking about above.
Oh, yeah.
Yep, shall.
Shall.
Good catch.
Thank you.
Okay, so we've got 3 requests. Line 4 may changes to shall, lines 5, 6, and 7 are gone. And then trying to capture the intent to publish the data other than the demographic data but not get on the wrong side of the public records laws. So let's committee be back here just before 11:30 and be ready to go at 11:30, assuming that it does his magic by then. So we'll be ready.